We are taking study section 5 of CIL, that is business law. And this evening, we shall be discussing on breach of contract, on remedy for breach of contract. We are looking at breach of contract, remedy for breach of contract, and discharge of contract. So at the end of this study section, you should be able to, one, explain the meaning of a discharge contract, or explain the meaning of discharge of a contract. Number two is that we should be able to highlight the method of discharging a contract. And number three, we should be able to explain frustration and its elements and effects. And lastly, we should be able to mention and explain the remedies for breach of contract. Those are the things that we are expected to know at the end of this study section. So we'll go on straight into the body of the work. What is the meaning of discharge of contract? A contract is said to be discharged when the parties that are involved in the contract perform the responsibility that is agreed in that particular contract, or subsequently agreed, or fundamentally fail to perform the agreement. Then no further obligation shall be on parties. So when a contract comes to an end, where there is no further consideration or further performance that is expected of the parties in that contract is said to be discharged. So we can simply say a contract is discharged when all the parties in the contract perform the responsibility agreed in the contract. It could be discharged. But where they do not perform the responsibility, it could also be discharged where they fail totally to perform the responsibility, or where circumstance make them not to perform the responsibility. They will be discharged and not be allowed to be involved in further performance of that particular contract. And this is what we basically refer to as discharge of contracts. We now move on to look at method of discharging a contract. What are the methods that could make a contract discharge, or under what circumstances could contract be said to be discharged? There are 4 circumstances for which a contract could be discharged. There are 4 methods of which a contract could be discharged. 1, by performance. A contract could be discharged by performance. 2, by fundamental breach of the condition of the contract. 3, by agreement. And 4, by frustration. So that means there are 4 methods for which a contract could be discharged. A contract could be discharged by performance, a contract could be discharged by fundamental breach, and a contract could be discharged by an agreement. Finally, a contract could be discharged by frustration. But where a contract is discharged by agreement, the agreement could take either of these following forms. It could take variation, it could take rescission, it could take novation, it could take accord and satisfaction, it could take promissory extope, or it could take contract of uberimei fidei, that is contract of optimus good faith. These are the method of discharging a contract. We now move on to look at it. We have said earlier that there are 4 methods, there are 4 ways for which a contract could be discharged. A contract could be discharged by performance, a contract could be discharged by fundamental breach, a contract could be discharged by agreement, and a contract could also be discharged by frustration. Now we want to take the first one, discharging a contract by performance. Now, when you talk about performance, when the parties in a contract perform the responsibility, perform the assignment assigned to each of the parties as contained in the contracting document, that contract is said to have been discharged by performance. But we now know the complexity nature of man, or the complexity nature of human being. Then we now have this performance could take either of these 4 forms. That means there are 4 ways for which we can categorize performance. Performance could be full performance, could be substantial performance, could be part performance, could be total non-performance. That is when you will talk about the performance in the discharge of a contract, those performance could take any of these four forms. It could be full performance, it could be substantial performance, it could be part performance, it could be total non-performance. Now, when you talk about full performance, as the name connotes, full performance simply means all the parties involved in that contract perform the responsibility that is agreed in that contract. And this is called diminished doctrine. So we call it diminished doctrine. This doctrine specifies that parties in that contract fully perform all the agreed responsibility that is contained in that contract. Then number two, we talk about substantial performance. Under the substantial performance, it is a situation where majority of the responsibility assigned to parties has been performed, and the other side that is not performed is so minute that the court could say that the contract has been reasonably performed and said the contract could be discharged by performance. But under this circumstance, the totality of the contract is not performed, but substantial part, majority part, a reasonable part of it has been discharged. So the court, in his opinion, could draw the conclusion that that contract could be discharged by performance. Then we talk about part performance. When you talk about past performance, when this arises, when there are two parties in a contract and one of the parties has performed his own side of the agreement, remaining the other party to perform his own other side. And where the other party did not perform his own responsibility, the court will not allow the person who did not perform his responsibility to take advantage of the person who has performed his responsibility. Under Section 4 of Statute of Fraud, it is stated that some contract must be by written. Example, contract of lease, contract of assignment of land. And under the contract of assignment of land, the seller of the land is called the assignor, and the buyer of the land is called the assignee. So when one party has signed a document, particularly the assignor, and the other party did not sign, the law says that the person who did not sign will not be allowed to take advantage of the other party. Or where an oral agreement is entered and it is reduced to writing, and one party has performed its own responsibility, the law will not allow the other party to take advantage of the party that has performed his or her responsibility. Total non-performance. In this case, none of the party performed the responsibility as agreed in the contract. Therefore, the contract could be discharged for non-performance. In other words, it could be said that there is no contract between the parties that are involved in the agreement. Then we move on to the second aspect, discharge of a contract by fundamental breach. Discharge of a contract by fundamental breach. A contract is said to have been breached when a party unilaterally refuses to fulfill its own obligation in the contract. When you talk about a breach of contract, you are saying that there are two parties in a contract and one of the parties has performed its responsibility and the other parties on its own fail to perform his or her responsibility. So where a party in a contract fail to perform his or her responsibility is a breach of contract. So a breach of contract arises where a party unilaterally on its own fail to perform the responsibility as agreed in the document of contract. And when you talk about a breach of contract could take different category. It depends on the gravity of the breach and the remedy that is available to the aggrieved person. Then we talk about breach, but we talk about fundamental breach. When you talk about fundamental breach, a fundamental breach is a breach of contract on the part of the person who breaches the contract that strikes at the root of the contract. In other words, it strikes at the heart of the contract, which renders the contract void. In other words, the person who breached the contract strikes at the root of the contract, and the person who suffered loss from the contract can make the contract void. In other words, it is a breach that will make the contract not to be binding on the other person. Then we'll talk about anticipatory breach. When you talk about anticipatory breach, this is a breach that is foreseen by one of the parties in that contract and make provision for it. And the other person may repudiate the contract in line with the anticipated breach or move along and sue for damages as the case may arise. Now, where there is a breach of contract, what are the remedy that is available to the person who suffers loss under a breach of contract? Because whenever there is a breach, whenever there is a wrong, there is a remedy. Ubi jus ubi remedium. Whenever there is a wrong, there's always a remedy. So if a party suffers loss arising from breach of contract, what are the remedy that is available for the party or the person that suffers loss? Number one, the person who suffers loss in contract will sue for damages. And this is the monetary compensation that is given to the person who suffers loss in any contract. That is what we refer to as damages. It is the monetary consideration, it is the monetary compensation that is given to the person who suffers loss under a breach of contract. And this was established in Univar Vulcanizing Nigeria Limited versus Ijesha United Trading and Transportation Company Limited and 6 others, 1992, 9th Nigeria Weekly Law Report at part 266. Then we talk about the first remedy is damages. The second remedy is rescission. And when you talk about rescission, rescission is an equitable remedy available to the party or the person who suffer a breach of condition in a contract. Under this circumstance, the person who suffers loss terminates the contract, and brings the contract to an end and makes it void. That is what we refer to as rescission. Then another remedy that is available for breach of contract is specific performance. And what is specific performance? It is also an equitable remedy where the court will order the party who breaches the contract to go back and perform the agreed responsibility that is imposed on him by that contract. Under specific performance, which is also an equitable performance, it is a type of remedy in a contract where the court will order the party who committed the breach of contract to go back and perform the function that is expected of him as contained in the contract document. That is what we refer to as specific performance. We also talk about an injunction. An injunction is also an equitable remedy, and it is an order of court restraining a person from doing a particular thing. So an injunction is an order of court stopping a person in a contract not to do a particular thing. So it is also an equitable remedy. Then we talk about quantum merit. Quantum merit. In this case, there could be partial performance of a contract. And when you talk about quantum merit, this is when the court will order that payment should be made to the level of performance that has been carried out in that contract. That is, a person performs a contract but did not perform the contract fully. The court will order that that part that is performed should be paid for, and the part that is not performed should not be paid for. And that part that is paid for, which is performed, is what is called the quantum merit. So the quantum merit is a remedy that is available where the court will order that part of the contract that has been performed should be paid for, and the part that has not been performed should be left unpaid for. We still went on. We are still discussing remedy for breach of contract. You talk about repudiation. When you talk about repudiation, you are saying that the person who suffered loss has the ability to repudiate the contract by bringing it to an end. So repudiation is the ability of the person who suffered loss in a breach of contract to bring the contract to an end. Then another remedy is restitution. And when you talk about restitution, restitution simply means returning the person who suffers loss in a breach of contract to his original position as if the loss did not occur. So restitution simply means returning the injured person, either in property terms or in monetary terms or its equivalent, to his original position as if he has not suffered loss at all. Then we talk about ratification. Ratification, these are cases where the terms of the contract may be rewritten, in order to reflect the true intention of the parties, meaning that there is a breach of contract because parties could no longer be bound by the content of the document. So parties are at liberty to rewrite another terms of agreement. So where parties decided to rewrite another terms of agreement in order for them to be bound, we refer to it as rectification as the remedy of a breach of contract. Then we now move on to the discharge of a contract by agreement. And when you talk about contract, all contract is an agreement, but all agreement is not a contract. And this agreement may be contained in the document of contract as available to parties. So when parties come together and they agree on a particular term, it is binding on them. But where circumstances comes up that they could not perform the contract, then they could also come into further agreement to waive or to amend the contract and ensure that parties perform their contract. So when you talk about discharge of a contract by agreement, it could take any of these following form. Number one, variation. When you talk about variation, this arises when the parties in a contract come together and mutually amend the terms of their contract. That is, the two parties that are in the contract, all the parties in the contract, they come together and amend the terms in the contract to enable parties that are in the contract to perform their responsibility and ensure that the contract is performed and discharged. We refer to it as a variation based on agreement. Then we talk about rescission. This is when parties to an executory contract mutually decide to discharge each other from the obligation of the contract. In other words, there could be some clauses in the contract that make some obligation difficult for them to be performed. And if they do not remove that clause in that agreement, they may not be able to perform that particular contract. So where parties come together and unanimously agree to remove some clause, to remove some agreement that is contained in the document to enable parties to perform their duty, we refer to it as rescission. And this could be expressly done or could be inferred from the conduct of the parties in that contract. Then we are still talking about discharge of a contract by agreement. It could also take the form of a waiver. And when you talk about a waiver, that is one of the parties in the contract decided to waive its rights in order for the other parties to perform its contract and make it discharged. So where one of the contracting parties chooses to grant a concession to the other party voluntarily without insisting on his own rights, we refer to it as a waiver, which is a method of discharging a contract by an agreement. Then we also talk about innovation. Innovation simply means when a new contract is substituting an old contract, an existing contract, we refer to it as novation. So novation arises where party uses a new contract to substitute the existing contract or an old contract. So that new contract is a novation of the old contract that has been in existence. But what is peculiar is that the new contract that is brought into existence will now have its own terms and conditions to be contained in that contract. Then we are still discussing of discharge of a contract by agreement. We talk about accord and satisfaction. An accord and satisfaction is a circumstance where a person paid lower amount for the amount he owed to another person in order to discharge the debt. We say accord and satisfaction arises where a person is released of debt by receiving a lower amount compared to the amount that is being owed to that person. That is what we refer to as accord and satisfaction. And in this case, the accord is the agreement that is reached by parties to accept a lower amount for a higher amount, while the satisfaction is the amount paid by the person who is owing the money. Under the general rule, we are also subjected to the law of England, which is the law of the Commonwealth of Nations. Under the general rule that when you pay a liquidated sum of money And what is liquidated sum of money? A specified sum of money. When you pay a specified sum of money, which is lower than the original amount of money you are owing, the law says that you are bound to pay the balance of that money, except to furnish a consideration for not paying the balance of the money. And that was the common law rule. However, there are exceptions that when you pay a lower amount, you will not be compelled to pay the balance of that amount. What are the exceptions to the general rule? One, where the payment is in form of something else, that is in kind, in form of wristwatch, in form of gold, in form of any article. That is when you are owing somebody 1 million naira and the person said you should pay me 300,000 and you should forget the rest. The law says that the person can come back to ask for the 700,000 naira balance under the general rule. But under what circumstance will not allow the person to ask for the money? It's only one, when you pay in kind. That is, the 1 million naira is paid in form of articles or items that you use in paying the person, but not cash. Number two, where the payment is made in some other places, station, than was formally agreed by the parties. In other words, if the money was to be paid in Lagos and the person now received the money in London, the law says that he will not be entitled to the balance of the money. But when you are owing a person in Lagos 1 million naira and you paid him 300,000 and said you should forget the rest, he can come back to ask for the 700,000. Because the place of payment is not different from the place of owing. So he can come back. But where the place you agree to pay him is different from the place where he received the money, the law says that he will not be entitled back to that balance. Now, when the money is paid by third party, where payment is made by third party, meaning that if you are owing a person 1,000 naira and the person is asking for the money and somebody help you to pay 400 naira and he said he's going to accept 400 naira in terms of 1,000 naira, because the money is paid by a third party, you will not be entitled to the balance of 600 naira. But when you pay it yourself, you will be entitled to the balance of 600 naira. These are the decisions of the court where accord and satisfaction does not exonerate a person from not paying the balance of the amount that is agreed. Then we'll talk about the principle of estoppel. When you talk about the principle of estoppel, it is also an equitable remedy that when you promise a person and you allow the person to act on your promise, you will be stopped to deny that you did not make the promise to that person, that your promise is binding on you. This was the case that was established in Central London Property Trust Limited versus I3 House Limited, simply referred to the I3 case. In this case, the plaintiff leased a flat to the defendant for 9 years on annual rent of £2,500 in 1940. Owing to the effect of economic depression arising from the World War II, the plaintiff agreed with the defendant to reduce the rent to £1,250 per annum. The defendant duly paid the rent between 1940 to 1945. After the war in 1945, the plaintiff demanded for the payment of full rent as the arrears waived between 1940 and 1945. It was held that the plaintiff could not renege on his promise to reduce the rent as at then. This is the principle of estoppel, that when you promise a person under a contract to perform a responsibility and such a person relies on your promises and alter his original situation, you cannot come back to say that you did not promise. And that is the principle of the promissory estoppel. Another contract could be discharged by agreement. What we refer to it as contract of uberimei fidei. Uberimei fidei is a contract that requires utmost good faith. And when you talk about contract with utmost good faith, it is a form of contract where you have to speak all the truth that is available in that contract. And some of these type of contracts are contract of insurance, that when you are going into the contract of insurance, you are the insured. The insurance company is the insurer. You are supposed to disclose all the relevant facts about the items to be insured. Then contract of sales of land. Under the contract of sales of land, if you are selling land to anybody, you must be able to tell the person any defect, any problem that is associated to that land. Where you fail or neglect, disclose any fact or defect on that land, that contract will be said to be void. Contract of guarantee, suretyship, and apprenticeship. When you are standing a guarantee for a person, you must be able to tell the person, the other party, that you know the character of this person, you can talk about the character of this person, everything you know about the person, you are expected to disclose it. Where you fail to disclose the relevant fact about the person you stand guarantee for or suretyship, it rendered the contract of guaranteeship void and not valid. Contract of family settlement, that when you are contracting a family settlement, you are arranging family property, and you are contracting a person under a family marriage, you are expected to disclose all the relevant facts you know about yourself, you know about the family property. Rather than that, the contract becomes void. We also talk about prospectus of company. When the promoter of a company needs to float a company, he should be able to disclose the relevant facts about the first directors of the company and the subscriber of the shares of the company. Failure to disclose this relevant facts renders the contract null and void. We are still talking about the contract of uberimei fidei, which is the contract of utmost good faith, which is a type of contract where parties need to disclose all the relevant facts that it knows about the item to be insured. But what are those facts that are not fundamental, that doesn't need to be disclosed or render the contract void? Number one, fact not known to the insured. If the person that wants to be insured does not know about the fact, does not need to disclose it. You cannot disclose what you do not know. Number two, fact which diminish rather than increase the risk. Number three, fact within the knowledge of the insurer. And number four, fact which the insurance waive under its rule. These are facts that doesn't need to be delayed. But we need to now go to a different heading. Failure of either side to disclose facts amounts to fraud, which makes a contract voidable. In other words, there are contracts you may enter into where the parties in that contract fail to disclose facts. It does not make the contract void. It makes it voidable. And once it is voidable, parties can see benefit from it, and parties can still go into the contract. Example, when a laborer does not disclose true facts about himself. If a laborer, if you are a daily laborer, and you are saying you are an engineer, you are a horticulturist, you are a greengrocer, instead of you to say, I'm a daily labor, you start painting yourself, you are a roadside mechanic, you are calling yourself a qualified engineer. What is roadside mechanic? What is qualified engineer? It makes the contract voidable. So in this case, you are not disclosing the true facts about yourself. Now, number two is if the breach not to disclose has been refused to be someone else. In other words, where the non-disclosure does not fundamentally affect the clause in the agreement. Number three, it is a breach not to disclose that one has been convicted. So where a situation requires somebody to know about the true status of a person, and such a person has been a convicted criminal, it will be a breach on the part of that person not to disclose he has been convicted as a criminal before now. Then we'll move on to the last aspect for the discharge of a contract. And we say contracts could be discharged by frustration. What is frustration? Frustration is that situation which makes the parties in the contract not to be able to perform without their fault. So a frustration is a situation whereby a contract could not be performed due to no fault of neither party. That is, they are unable to carry on the contract not because of the fault of neither of the party. So a contract is said to be discharged if there is no fault of either party, and it becomes impossible for them to perform the obligations that is contained in that contract. So when situation occurs and that situation does not enable parties to perform the contract, we refer to that situation as frustration. And frustration could take any of the following. Number one, destruction of the subject matter. When the subject matter is destroyed, you have to take note that in some situation, frustration could be referred to as force majeure. So when you talk about destruction of the subject matter, If the subject matter is destroyed by nature, such as earthquake, volcanic eruption, rainfall, flood, or accident, and it does not make parties to perform that assignment, we say the subject matter has been frustrated by the call of nature. For example, you want to purchase a house and the house is located somewhere and rain fell yesterday, and that rain that fell yesterday generated flood, and the flood wiped out the building, and the transaction could not continue. The transaction could not continue, not on the fault of the buyer or the fault of the seller, but nature wiped away the building through flood. In that case, we refer to that flood as frustration. So frustration could be the destruction of the subject matter by natural occurrence, which could be by earthquake, volcanic eruption, rainfall, flood. Then frustration could also take place by death. If the person who is expected to perform personal service, died before the performance of that duty, the contract is said to be frustrated by death. Then cancellation of event. If the event that has been slated has been cancelled by authority, then whosoever have a contract for the performance on that date, it will come to an end. Where performance is rendered illegal, where parties enter into a contract, and as at the time they enter the contract, this was a legal contract, and as at the time they want to perform the contract, it has been declared illegal by the government. That contract is said to be frustrated by illegality that is declared into that contract. So a contract could be declared illegal, and once it is declared illegal, it will be frustrated by such declaration of that contract to be illegal. What is the effect of frustration of contract? And we're looking at the effect of frustration of contract under the common law principle and under the law reform principle. Under the common law principle, number one, the contract is automatically terminated and both parties are subsequently discharged from further performance. Number two, all parties that have already accrued, all rights that have already accrued prior to the frustration of the contract shall not be affected. However, number three, where a person has paid some money in advance and nothing was forthcoming before the frustration, is entitled to recover such money for failure of consideration. This is the position of the common law. But because the common law does not satisfy the yearnings and the aspiration of the people, the law reform of the Frustrated Contract Act 1943 in the United Kingdom provided another two clauses. And these clauses provided under the law is one, on frustration, all sums payable before the term of the discharge shall cease to be payable, and all sums paid shall be recoverable. But a party entitled to such payment may retain or recover the whole or part of such sum not in excess of the expenses that has been incurred. What is the meaning of this statement? When you pay, for instance, you pay for a building that you want to rent that building, and the money you pay for that building is 10 million naira. While you pay the money, they use part of the money to paint the house, they use part of the money to put electricity in the house, but before we knew it, fire came from nowhere and consumed the building. We refer to it as a frustration. Now that is frustration, you cannot collect back all your 10 million. You can only collect back part of the money that has not been spent on that building. Part of the money that has not been spent on that building. But when no amount has been spent at all on that building, you're entitled to the whole 10 million you have paid for that particular building. Number two, if a party obtains a valuable benefit before the discharge of the contract, the court may award the other party any sum it thinks fit, not exceeding the value of the benefit received. Thank you very much. We'll meet again in the next class. My brother.